Good morning and welcome to the authors panel discussion. And congratulations to all of you for making it to the international rounds of the Jessup Moot Court competition here in beautiful but chilly Washington, D.C. My name is Goodwin, and I'm a senior lecturer in law and the director of Indiana University Maurer School of Law's Graduate Legal Studies program. It's an honor for Indiana University Maurer School of Law to sponsor the authors panel discussion, which gives you a unique opportunity to hear from the authors of this year's problem and even get an answer to your most burning questions. As the director of the law school's graduate legal studies program, which includes the master's and doctoral degree programs, I travel to law schools all over the world, meeting with students, faculty, and alumni. Over the last few months, in every country I visited, I watched as students struggled with and prepared for this year's competition, trying to make sense of a complex problem concerning the right to political expression, statelessness, the right to a nationality, and the scope of the UN Security Council's authority in settling disputes. I met with applicant students who tried to find ways to help Dr. Malix to enter Amicia, and respondent students who explained to me the challenges faced by the late Ms. Saki Shah. These are serious and incredibly relevant issues today, and the world needs more highly trained legal professionals with expertise in these areas. In fact, many of us at Indiana University Maurer School of Law do work that includes and promotes an international law perspective. My own research involves international cultural heritage law and policy. And in just a moment, you will meet my colleague, Professor Asaf Lubin, whose areas of expertise include public and private international law, cybersecurity and national security law, and international human rights and humanitarian law. The Master of Law program at Indiana Law offers a number of specializations where students can choose to focus their studies on international law and how international law intersects with other subjects such as cybersecurity and information privacy, intellectual property, financial regulation and capital markets, and business and commercial law. Moreover, students who complete the LLM program may be eligible to sit a bar exam in the United States, and we have many alums who are now practicing attorneys in this country. Much like the Jessup competition, which is a one-of-a-kind experience that nurtures students' interests and prepares you to engage with the global legal profession, the LLM program at Indiana University Maurer School of Law is also unique in that it offers a high degree of specialization and opportunities for students to choose their own path, fully supported by a world-class and globally engaged law school. To learn more about our programs, I invite you to pick up a brochure or business card on the table in the back, and I'll be here after the panel discussion today if you have any questions. And now I'll excuse myself and cede the floor to Dr. Asaf Lubin, Associate Professor of Law and Fellow at the Center for Applied Security Research at Indiana University Maurer School of Law, and the MC of today's panel discussion. Thank you.
So good morning, and I'm delighted to be here. I am not the author of this year's problem, and so I will keep my remarks extremely brief because I'm not the reason you all came this morning. You came for the people sitting to my left, which I will introduce to you in just a moment. But I will say three brief remarks at the outset. The first is that I hope the experience you've all gotten from doing the Jessup International Law Moot Court competition did not only inspire you to take a career in international law and consider more profoundly professional tracks, but also the possibility of taking graduate study programs. I did the Jessup in 2011, and shortly thereafter took an LLM and JSD programs here in the United States, and they have dramatically shaped my entire career and allowed me to become a law professor. So while I hope you'd consider the Indiana University Maurer School of Law as your school of choice, and I have good reasons why you should do that, any program would be an amazing experience for all of you and will enrich your academic and professional careers. So that was remark number one. Remark number two is that The Jessup Moot Court competition is one of those competitions where the vast majority of the participants lose. That's the design of the program. All of the participants, except for one team, will lose the competition. And therefore, thinking about winning and losing in that kind of way is the wrong way to think about winning and losing. Winning this competition is doing this competition. Coming to the international rounds is already a cherry on top of a huge ice cream sundae. And what I hope you take out of this competition is the community that it enriched your life with. As I said, I participated in 2011, but I've stayed involved in the competition ever since. I wrote 2 problems and have been in the editorial committee of the competition since 2016. I got to meet some of my best friends. I got to learn so much international law. And most importantly, I got to interact with decades of students who still to this day come to me and say, you judged me in year so-and-so, and I have to apologize for whatever I did during that round. So the bottom line is come back to this competition. The competition will not exist if there is no support of the kind that you can offer as national administrators and coaches and judges. Come to the international rounds. It's a lot more enjoyable from this side of the panel than the side that you all spoke from. So that was point 2. My last remark before I introduce our authors is to shed a little bit of light about the editorial process. So you see a final problem, a polished problem, come to you in September. But leading up to that moment are dozens of drafts being passed around between the editorial committee and the authors as we hash out different challenges of narrative and legal issues throughout that problem. And that is a very long and taxing process. But one of the things that is particularly challenging in it is to ensure a balanced problem. So what is about to happen soon is that you're going to grill our authors about everything that you think went wrong or that you wished was there. In doing so, I just want to remind you the challenges of drafting this thing and trying to find the right balance of equities between the parties is a really difficult thing. And so just show some mercy. Still grill, but show some mercy. All right. With that, I'm going to stop talking. That's the end of my talk, and I'm going to now introduce our 2 amazing co-authors with years of Jessup experience. So what I'm going to ask each of them to do is I'm going to introduce them and ask them to say a few brief remarks about what they've experienced from this year before we open the floor off to you. So I'm going to start with my far end. That's Jeffrey Brooks. He's a member of the law faculty at the Louisiana State University Law Center. Professor Brooks teaches international law, and he is the director of LSU's Moot Court program. He is also a longtime administrator of the United States National Rounds of the Jessup, and he was the author of the 2017 Jessup Compromise. Jeff, please.
Good morning, everyone. Move this a little closer. The experience of writing this compromise for me was a wonderful one. I came to it, Dagmar, who you're going to hear from in a moment, came to me and said, I have ideas. Do you have ideas? Because I would like for us to write a compromise together. And I thought, oh, why not? Sure, that sounds fun. Because she and I were thinking about things that interrelated. You're going to hear about hers. For me, the thing that I've been thinking about a lot is we're 100 years on from the PCIJ's decision in the nationality decrees in Tunis and Morocco case. Where is that case now in 2024? What does it survive in any shape, in any way? And so what I was hoping to do with this compromise is weave the question of domaine réservé throughout all 4 issues so that you're thinking about what is still reserved to a sovereign state in this world of international organizations, of human rights treaties, of increasingly interlocking obligations between states. Could the ICJ still make the pronouncement it made, well, its predecessor made, in 1923, and that was the thing I wanted everyone thinking about, and I think I got there.
Thank you so much. Our next amazing co-author is Dagmar Butte. She is a former ILSA board chairperson and a co-author of 3 previous compromise, and has been involved in the Jessup as a coach and judge since the 1990s. Originally from Germany, she is a nationality and migration lawyer in Portland, Oregon.
Poor Jeff. you were sitting in that lobby and you just couldn't say no.
She trapped me.
I did. It was the lobby of this hotel, just so you all know. So be careful what you do in the lobby. No, I also had a theme, but it was prompted by something that I saw in the news right before I was here last year, and that was El Salvador stripping the nationality of people critical of the government who were writers and poets, and putting them on a plane to Washington, D.C., and it got virtually no attention, generally speaking, and I thought, can they do that? I looked, and sure enough, maybe they can. But like Jeff, I've also always had a particular thing I wanted to move forward in international law. And people think it's just erga omnes or erga omnes partes, or for those of you who have read Dr. Seuss, the Lorax, but that's not really it for me. I wanted to move forward and still do the notion of making international law more effective. And that's also why we started talking about the Security Council in Chapter 6 instead of Chapter 7. If the Security Council can't get anything done with Chapter 7, maybe they can do something with Chapter 6. We'll see based on the last couple of weeks whether they are doing anything with Chapter 6. But those are my moves here. I was really, really interested in exploring how we can make international law and international institutions more effective.
Awesome. So with that, now you have a sense of what our authors have thought about when they introduced this problem to your lives. And now is your chance to ask them all the questions you are dying to ask. And so there's a microphone stand right in the middle. Don't be shy. Come to the microphone stand in front of it. There's going to be a whole line, because we've done this before. We know how this works. All you need to do is just introduce yourself. I'm so-and-so from team so-and-so, and then ask the question you have.
All right.
Thank you for being brave. Yeah.
I see no tomatoes, no eggs. This is good.
They're hiding them.
Right, so, well, first of all, thank you so much. I think I can speak for everyone that the compromise that you created also created, besides a lot of hard work, a lot of fun. So thanks for that. So my question was regarding the standing in Claim 4. Was that an original concern, or did that sort of pop up from the questions that you got from the original compromise, which then led to the paragraph 11 of the clarifications? And by means of paragraph 11 of the clarifications, that you mean to eliminate the problem of standing in Claim 4, or was that just like a byproduct that everyone just kept talking about?
So I think and I think the editorial committee agrees, when we write the compromise, we try to imagine everything that 700 teams of law students around the world are going to do with the words that we write. And we literally go word by word and think about what effect does Antrano being an archipelago have? Because people have talked about why Antrano was an archipelago. We thought about the standing concern. We did not think it would pop up as much as it started to bubble up. And when we got the request for clarification, we thought as a group, this is something we need to address, not to close the door on it, but to try to focus attention.
Okay, well then, thank you very much.
Hi, I'm Michaela from Temple. I'm curious, in the different submissions of remissia and Antrano, they use different wording, like Antrano uses dispute and remissia uses, I think, matter or something like that, but then there's something in the compromise to say that they both agree that it's a dispute. Was dispute ever supposed to be an issue, or?
That's a really short answer, no.
Okay, thank you.
Hi, I wanted to first of all really congratulate you because the compromise was really good. It touched really interesting themes. My question is, well, this will probably be a question of knowing what your opinion is on this matter, but do you consider, the CRS of erga omnes partes or erga omnes nature?
Do we consider what?
Do you consider the CRS, the Convention on the Reduction of Citizens, of erga omnes nature? That's my question.
I will tell you that I think there's a little bit of disagreement among all of us with respect to that. I don't think it's clear-cut at all. I have never met a treaty I didn't want to be erga omnes partes, but when I think about this one, there are challenges in establishing that.
No.
Hi, my name is Seven. I'm from Christ University, and I think I'm sort of speaking for everyone here in terms of voicing my thought or a question in terms of Article 40 and the second batch of basic materials, which was not supposed to drop and then dropped in, and then we had to leave in Article 40. Considering that the Security Council very much could have created obligations under Clause 2 through an implied reading under Article 24, I'm just curious, was the specific mentioning or an indication towards Article 40 maybe drawing towards a conversation that should happen now with regard to how Article 40 could happen or take place without a determination under Article 39? I'm just curious of the thought process that went there.
So I think we made a lot of decisions about Article 34, Article 39, Article 40 well before the Security Council's authority in that area was becoming a real pressing issue. So we were working much more off of history than we were off of more recent events, because we settled on those things well in advance of recent developments. And I will tell you that of the 4 questions presented, the 4th went through far and away the most change over the course of the writing. And the Security Council's power was invoked under pretty much every article that they had at some point in the writing process. And we ended up at Article 34.
And I got the job of writing the resolution, and I tell you, that was stressful. I think that was more stressful than writing any other part of, of the piece. So yeah.
I suppose it was well balanced, so kudos to you.
Good morning. I have 2 questions. So the first one is regarding Claim 3 of consular access. I want to know whether you want the voters to make the link between consular protection and diplomatic protection.
That was a huge question, I think.
It is, but I'm not sure I caught all of it. I'm so sorry.
Do you intend for the voters to make a link between consular protection and diplomatic protection?
Oh, yeah, okay. Yeah, I think we were really, really focused much more on the rights of Remisia with respect to its nationals. And things started to drift, I think, over time into the substantive rights of Ms. Shaw herself. And that actually made it a more interesting discussion, but not one we had originally contemplated.
And that's why she had to die.
Yes, that is, and listen, that's really true. That is why we killed her.
But she's not dead.
And for the second question, I want to know about the immigration officers in Toronto. Like for that part, is there any legal issue to be respond?
I missed the first half of the question because people were laughing.
The immigration officers of Toronto, when they made an error stamping the passport of Remisia, is there any legal issue to be addressed in the submission?
So the idea of estoppel was one that we floated around, and then we thought, perhaps we don't want you focusing too much on estoppel, and so we, in the corrections and clarifications, started.
Whoa.
Wow, even more dramatic.
Saki Shaw from the dead.
We're sorry. So we tried to pull back a bit on the estoppel argument, so again, to focus you on the issues that we wanted you to be talking about. Does that make sense?
Yes. Thank you.
Hi, I'm Sparsh. I'm from National Law University, Delhi. And I just had one question that during the drafting of the compromise, did you guys consider making the state detaining Ms. Saki Shaw her state of nationality?
So which nationality?
So the state detaining Ms. Saki Shaw, was the idea floated that this state detaining Ms. Saki Shaw should be a state of nationality?
Yeah, I think we should. All right, so Saki Shah had many nationalities as we went through this, and nothing seemed to work until we realized that there was a perfectly wonderful candidate. And so for those of you who have your smartphones with you, I would like you to Google Mulvania
If
and
you
look
haven't already.
carefully at the image if you haven't done so already. We'll give you a few secs.
I will say I wanted Saki Shah to be from Genovia and not Mulvania, but I was overruled. Was that what you were looking for?
Also, just one more question, if I may ask. Is there a principle or jurisprudential reason why the test of dominant nationality should apply to third state?
About dominant nationality?
We didn't really think about that so much.
It wasn't something I think that we weren't really looking for a discussion of dominant nationality. We were, I think, and this was, I think, Dagmar's interest, really looking at dual nationality. And,
Yeah.
Yeah, and testing not a bomb.
Yeah.
Thank you so much.
Your Excellencies,
Oh,
No.
no, don't you dare.
when I come from China, I have a rather abrupt question today because when I'm analyzing whether from the applicant and the respondents, try to figure out whether the rivalries to nationality really matters in current days. Because I figure out when the Hannah Arendt firstly presented the concept, the right to have rights, but 70 years have just passed, and we have numerous human rights treaties. Not only the CSP, but the ICCPR, ICESCR. So in my opinion, that in numerous the developed countries, those states persons, they even do not figure out that they are stateless until a certain years, like what is in the beginning we heard about from that person. So my question is, when we are discussing about whether this shall be protected in an ergans partis level, we try to find numerous practices like those in the northern Syria or in the Myanmar or in Eritrea. But in my opinion, they are not only by the reason of lacking of nationality, but also by the torture, genocide, or the use of force themselves. So my question is whether in the modern days with the protection, international protection, the right to nationality really matters in that way.
Oh, I think
Absolutely, absolutely. I mean, I was kind of originally thinking about the fact that after World War II, there were millions of stateless people, and it's one of the reasons so much attention was focused on it. But when you look at what the UNHCR is doing right now with its initiatives with respect to a right to nationality, I think they get it right. Having a nationality is the root of all of those other rights. Yes, if you have a stateless person in your territory, you owe them certain duties, but having a country, I think, is hugely significant both legally and as a human. I think it matters.
Yeah, I think that if we're stuck with nation states, and I think we are, at least for the moment, belonging to one of them matters a great deal, and not belonging to any of them really renders you powerless in so many ways. And so I think absolutely having a nationality matters very much still.
So maybe it not only cares about the protection of human rights, but also a state to protect, like the consular or diplomatic protection. Thank you.
Hi, I'm Basu from National Law University, Delhi. I had the privilege of being judged by Professor Jeffrey in our final round. And my question relates to one of the arguments that we made. In issue 4, was it at all something from the respondent or from the applicant to consider the difference between an Article 34 investigation and a fact-finding mission? Was that and specifically using the words of the mandate of the mission, was that at all something that parties should have considered?
Yes, 100% yes.
So that is a valid thing to say that fact-finding needs state consent, unlike 34.
Yep, absolutely.
Thank you.
Good morning. I'm from China, and firstly, I want to say thank you very much for giving such a fantastic problem for our Jessup this year. And I have 2 questions. First is about the compromise. After arresting 7 El Salvador protesters, it is the Minister of Mining who orders releasing the 7 persons. So I think it is a little bit weird because maybe it just fell within the power of the Minister of the Justice. So I think could be posed as an arbitrary application of the master law of Indonesia. So it is by intention or by accident.
It was by design. Yes, so we wanted the Minister of Mines to suddenly be developing a lot of power in Remisia. So yes, the actions of the Minister of Mining were intentional.
And my second question is about the issue 4. I think I want to know that whether have you considered that the meeting record of Resolution 997 should be or might be added in the appendix, the meeting record of 997. Because I think it is a strong evidence to prove the legal consequence of this resolution.
Sorry, what should be added to the appendix?
The meeting record.
Oh, the minutes of the meeting?
It's a meeting record of Resolution 997.
Well, that would have been nice, but we don't give you the facts that make it easier, so we left that out.
Yeah. So so Dagmar and I worked a lot on the resolution. And first of all, I apologize to everyone in this room for 99997. That was me.
That was all
That
him.
was
I had
all
nothing
me.
to do with that.
I did not think about saying it out loud. The goal was to get far away from any number related to any existing UN Security Council resolution. Didn't think about the fact that everyone around the world would have to say those numbers out loud. So I'm sorry. And then to the question of the minutes, we intentionally don't include them.
Thank you very much.
Yeah.
Hi, I'm Jean from Beijing, and thank you for your efforts. You provide us with an interesting story. So my question is, why there must be an investment nationality program? Because as for me, it seems that it makes the position of Toronto become a little bit self-contradictory, because at the same time, it is so dedicated to reduce statelessness, but at the other time, it just completely rejects the international effect of investment nationality program. And if that's a matter of law, if your purpose is to point us to the analysis of genuine link principle or effective nationality principle, you could make Ms. Shaw naturalized in a rather speedy way, just as the case as not in both with tenuous connections to Remisia at the same time, but without under a investment nationality program. So what is that rationale, or what is your concern when making this investment nationality program a necessary one? Thank you.
So one of our goals in writing the compromise as an entire document is to put the two agents in a position of having to make arguments that sort of push against each other's interests. And so having the first applicant and the second applicant agents having to make arguments about how far a state's authority over nationality goes in rather contradictory ways was a design choice. And so we settled on citizenship by investment as I'll rewind for a moment. Antrano and all of the people, all of the names in Antrano mean home or family or group in a language of the global south. And so Antrano is built around the idea of you come from a place. And so Antrano as a country, we thought would reject this idea that you can buy your way into our family, that you can buy your way into our home. And so it seemed logically consistent for them to take that position, but it also puts you as advocates for that country in a tense position of having to test the boundaries of how far your sovereignty argument goes versus your obligation to respect another state's decision on nationality. So yes, it was very much by design.
I get your point. Thank you so much.
One question for me. Since you brought up nouns, are there any other nouns in this story this year that you want to highlight the history or background for?
Yeah, so Dagmar told me I was in charge of world building because I can basically tell you what the people in these countries eat, what their GDP is. I spend a lot of time thinking about the world of the Jessup because I want the countries to feel as real as possible. Antrano, home, family, community. Remisia started off and for a long time was the country of Rokai. We wanted a country that felt grand, imperial, pretentious,
Jeff used the word fancy.
Fancy, yes. Something that felt old, elaborate, and existing, but then we didn't really like the word rocaille, which is a French architectural term. And so we started thinking about other themes in the problem. Remisia was mining cobalt. I thought, oh, cobalt blue. Cobalt blue is the favorite color of the Impressionists and Post-Impressionists. So Remisia and all of the names of Remisia's people are Impressionist and Post-Impressionist painters. Yeah, a long way to go to get there. But so that's why I was wearing a lot of stars last night, if you saw me. So the Stair 40 is Van Gogh's Starry Night. Remisia is Remy, which is where Starry Night was painted. Queen Cassatt is Mary Cassatt, and it goes on and on. The only name that we can't tell you the source of is Saki Shah.
We don't know where she came from.
She literally just appeared one day in a draft of the compromis, and we're like, oh, that's her name. That's it. We don't know what she truly, we were talking about it beforehand, no memory, no one on the committee remembers. Just one day, Saki Shah was there.
We thought it was Michael Pyle, and he's like, I didn't do that.
So, but every other name is intentional. Also, and this was a little slip into the problem, at a part you probably didn't read, one of the ambassadors to the United Nations is non-binary and uses they, them pronouns. So that just if you look back towards the beginning, the part you probably just skipped right past.
The part nobody reads.
But it's apparently the first time in Jessup's history that there's a they,
Yep.
them pronoun.
Yep, never done that before.
So we think about these things a lot.
Hi, I'm Apuvan, again from National Law University, Delhi, and I'm sorry we have another question coming up. But my question pertains to the first issue. Now, while over the week we have been debating whether the convention is erga omnes partis or not, my question is, even if we accept that and we go beyond that, the current debate is still whether that can lead to standing or not. And like the crux of the debate comes down to policy arguments on both sides. Like the proponents argue for an effective realization of obligations, while the opponents argue against a floodgate of litigation, a rebilateralization of these obligations. So did the compromise envisage going beyond this step and arguing on a policy level?
You know, that's an interesting question because in my head, when we were working on this, I thought, okay, the ICJ has now generally accepted the notion of erga omnes partis standing in a limited context, but generally accepted it. And I really actually was quite interested to see whether the right to have a country is erga omnes, straight up, a basic right of the human person. And I was very interested in the teams that did try to tackle that. It's a huge job to try and make that argument, but I was very much interested in that. I think, though, for the court's legitimacy, that's probably going to be problematic because of the way the court's jurisdiction is structured, the way adherence to the court's judgments is structured. I think straight up erga omnes, I think, will be a much, much greater challenge to ever be used.
Yeah, I agree.
Good morning. I'm Paul from Germany, representing Switzerland, and I have a brief anecdote to share and a brief question. So my colleagues and I, 2 days before we left for Washington, did a practice with a professor from our university. And we did our pleadings and everything, and after that he was like, well, good job, guys, but seriously, this is such a boring case.
We just didn't kill enough people, we're sorry.
Apparently. And I mean, I thought that's pretty rich coming from a guy who specializes in trade law, but I mean, different tastes, I guess.
That's funny.
The question is very brief. Did you want people to talk about the so-called genuine link requirement?
Do you want people talking about genuine link?
Sort of. I think that has more these days into effective nationality. So genuine link, I don't know.
Microphone.
Oh, sorry. Genuine link, I'm not sure that terminology survives.
So yes, but we were hoping for more.
Right.
Yeah, thank you.
Hey, so I'm Bruno from Brazil, but representing France. And I just have a quick question. Are there any red herrings in this case? And like in general, when you're writing a compromise, do you want to put like 1 or 2 red herrings just to throw some teams off? And if so, which are the red herrings in this case?
Oh, there's so many of them. There's so many of them.
Go ahead.
I'm trying to think of what ones that I heard argued.
Especially affected, the sentence about how much they care about stateless people. We heard some folks try to run especially affected arguments, and we definitely weren't thinking that that was going to be there.
So I think also, sometimes we think that a thing is a red herring, and then a team takes it.
Oh, that's a good point.
And finds a seed in it that we had never thought about, and it sprouts into a full-fledged, beautiful legal argument. So I'm not going to tell you what we thought may have been red herrings, because some of them actually grew into great pleadings, and I don't want to diminish anyone's work in finding them. I also don't want
That's true.
Yeah.
And also, I think the red herring notion actually occurs much more frequently between when the announcement of what the problem is going to be about is made and when the problem finally develops. This year, I think we were pretty good about describing what we were going to be doing, but I remember writing a compromise in 2005 where we announced that it was going to be about piracy. As we were writing it, we realized that the existence of the pirate created all kinds of problems for the other questions. And so, yeah, we had a pirate, but then he disappeared. And so the problem wasn't about piracy at all. So that sometimes happens.
Can I just make a public announcement about, relates to this, which is, I don't know how much teams really appreciate that process after the problem is published and when we call on you to ask us questions for the clarifications and corrections phase. It is vitally important that you engage in that process. The way we map out the red herrings and understand what is a problem or not a problem comes from this exchange the editorial committee, the authors, and you have with us at that exact phase. So if you're a team that has never participated in that process, participate in that process. You're directly affecting the results of how the case shapes up.
Strategy point on that, you get a limited number of questions, and we get this every year. Someone always asks, please tell us the legal pleadings you wish us to make. We're never going to do that.
Thank you very much.
Good morning, I'm Vedant from National Law University, Delhi. So I have a question regarding the 4th issue. Was it ever contemplated that the issue in question with regards to the distinction between, rather than like the distinction between Chapter 6 and Chapter 7 resolutions, was it there on your mind to test the limits of the general implied powers of the Security Council in general, and to what extent can this council take decisions in general for international peace and security? So
100% yes. Yes. Yeah. And that goes back to my underlying theme of where is domaine réservé now, and what is sovereignty in the world where the Security Council and the United Nations Organization and Article 2 exist. How far does the power of the Security Council go, and particularly the implied powers? So yes, very much so.
Also, one slight question on the fact that the states have denied entry to many rapporteurs and investigators in the past. So I mentioned about effectiveness of the law on international level. What had to be debated on that, given that they have actually denied entry and continue to do so, citing some reasons or no reasons, and the response, the consistent response that has been is with respect to moral condemnation on the international level. So how do we deal with that? What was envisaged there? Because again, comes to the question of enforcement. So what was to be discussed there is my question, because when we have so much evidence of the entry being denied on a regular basis.
I think there again, we were not so much looking at whether the respondent, whether the respondent could refuse someone, right? We were more looking at the process that people have to go through if they're part of such a mission, and what if that makes sense? How do you balance the rights of the state that's being, I guess, investigated, for lack of a better word, and the rights of the people who are coming to do that work? And it goes right back to Jeff's concern, which is domaine réservé? Where are we with that, right? So.
And what happens if a state says, no, you can't come
Right,
in?
exactly. And we definitely wanted to test that.
Thank you.
Hi, my name is Dana. I'm representing Germany. And my question relates to Claim 2. I was wondering if you wanted us to put the focus on the mere formality, whether the declaration by Rumija is a declaration or a reservation, or if you wanted the focus to be more on the content of Article 8.3, so the serious prejudice to the vital interests of the state, because I think the focus, at least in my pleadings, was more on the formality, and I was wondering why we don't focus on the content.
So we're all laughing because the number of emails that went between the authors and the editorial committee about what is a declaration and what is a reservation is truly astonishing.
In the end, it's neither.
Yeah. I think the challenge of Article 8 is we don't really know what that deposited text is. Is it a declaration? Is it an interpretive declaration? Is it a reservation? What is this document that Rumisia sent in with its ratification? I don't think the convention makes it clear. I personally don't think the ILC really could even answer that question. We wanted you to focus more on the substantive effect rather than what is this thing, because I don't think we really know.
Yeah, it's just triggering because I'm remembering all those emails.
Oh my God, so many emails.
Okay, thank you.
I can't search my email for the word declaration anymore. There are literally too many results.
Hello, I'm Diana from the University of Puerto Rico, and I just wanted to ask a question on issue 3. So we read the Notabomb case, and we drew some parallels between Saki Shaw's, like the subpoena being issued, the investigative report by Alethea, about the possible crimes she could have committed in Mulvania. And we drew a parallel between the motives behind Mr. Notabomb's acquisition of nationality, of Liechtenstein nationality, versus Saki Shaw's acquisition and her, the fact that after those investigative reports came out, that she started doing affirmative steps towards solidifying a relationship with Remisia. Was that, and the argument that the acquisition of Ms. Saki Shaw's nationality was in order to avoid being extradited to Mulvania.
No, that was never it, because your timeline doesn't line up. Subpoenas are given to people all the time, and that doesn't necessarily mean you're about to be charged with a crime. It simply means they're investigating whether a crime was committed, and you might have information, right? So your timeline, I think, doesn't quite line up because she didn't know that she herself then had been warranted for arrest. So at least to my mind, that argument was a very difficult one to make, particularly when you think about the notion of inferences in international law and what the Corfu Channel case had to say about that. I just don't think that that argument with the facts you were given rises very far.
But were we riffing on Notabomb? Absolutely.
Yeah.
Yeah.
Thank you.
Good morning. Camila Chamune from Zambia Cavendish University. My question is concerning issue number 3. So, was it that you wanted us to determine dominant and effective nationality, or rather the validity of purchased citizenship and passport?
I think neither. I think what we wanted you to determine was consular access. Who gets to determine who a national is, and what do they have to do when they've made that determination was really what I think we wanted you talking about, which then led you to have to think about questions of dominant and effective nationality, the recognition owed to another state's determination of nationality. But I think the fundamental question is, whose consul does Saki Shah get to see, and what does Antrano have to do to empower Saki Shah's consular access?
Thank you. Good morning. My name is Michelle. I'm also at Catholic University from Zambia. My question is, obviously from this case, we see that there are certain concepts and principles that will need to be amplified, like state listings, right? So by bringing out the concept of purchased citizenship, was it the intention of the drafters to bring out something or to point us to a direction of the position of naturalization by investment in the contemporary world? Did we have to really learn something from it or look into it? And yeah, I think that's it.
So yes, in the larger context of what is the status of a country's obligation to recognize another state's declaration of who their nationals are, one of the emerging debates is, of course, citizenship by investment. And so we thought that was a useful tool to get you thinking about what is nationality, what can a state say their national is based on currently. So that was my goal in thinking back to 1923 and the PCIJ's decision. Does citizenship by investment work? What's the current status of customary international law on it? Was absolutely a component of the third question.
Thank you. My second question is with regards to the nationality of Saki Shah in determining which context her consular access could be given. Were we supposed to, when we were preparing, we had a conflict between determining the effective or sufficient link in her dominant and effective nationality. And we also thought, wait, if they're not recognizing it, if they're not recognizing the purchase citizenship, then obviously they're thinking she's not a dual national at the end of the day. So is it necessary to then prove the dominant and effective nationality? So our question basically is, if it's a point where the state is not recognizing nationality, do you still have to consider dual nationality, and consequently, do you have to prove the sufficient way, or do you have to carry out the dominant and effective nationality test?
I don't know that we can answer that so much as to say that's what we wanted you to talk about. I don't know that there is an answer to that currently in international law. I think that is the underlying tension of the third question presented.
We just don't have enough background information, unfortunately, on Article 36 to really know. Because when all of that was drafted, that was less of a consideration. But today, nationalities proliferate. I know so many people with multiple nationalities, but I don't think they really spent a lot of time thinking about that.
One of my favorite questions to ask, and I'm sorry if you had to endure a version of it, is what if Saki Shah opened the suitcase and dumped out a suitcase full of passports and said, I want all of my consular access? What is Antrano's response there? How far does that go? Because many people have many passports, and do you get all of them?
And of course, also you've got that tension, right, between the detained person's right to be assisted by to make that choice of who they want to be assisted by, and then the obligation on the detaining state. And if you think about it in the context of dual nationality, that's a real tension between those two concepts.
So just a point of order. So I was given permission to extend, so the program ends this at 12. I was given permission to go to 12:15, but there's a lot of you, and so keep your questions brief and pick one. If you have multiple, just stick to one question. Thank you.
Good morning, I'm Gabriel from Italy, and I wanted to ask you, can you think the difference between the nature of the obligations of pay rate and the nature of the obligations, the imposition of responsibility, and standing was relevant in the case or not?
Yes. Yes.
I think so.
Yeah.
Yeah.
So that was short.
Yeah.
We're already compliant, Asaf.
We do as instructed.
Hey everyone, I'm Sam from Boston University, Day 1923 judgment, and then Article 1 of the Hague Convention, and a lot of more recent things reiterating that you have to recognize another state's conferral unless it's illegal in some way or contrary to international law in some way. And if that's accepted as custom, Article 1's accepted as custom, then you would think the applicant would have to show like an affirmative custom against citizenship manifestly.
Every applicant I saw got that question from me. Yes, absolutely.
Right. So I was just wondering to what extent you think, were you expecting us to accept that Article 1 of the Hague Convention, or kind of that principle of recognize unless it's contrary to something? To what extent do you think that's like the starting point of the problem?
I think it's a starting point. My position, I mean, I always go back to North Sea Continental Shelf and what is customary national law, and I never think there's one kernel, one source of custom. Custom requires showing more than that. So I think, yes, it's a starting place to start thinking about it, but it's not enough to get custom by itself. You have to show the river of law.
Hi, I apologize.
You can pull it down.
I tortured them for 2 hours.
I'm Samane from ATU from Iran. I have this question that in issue 4 of the applicant, you have emphasized on Antranen national Dr. Thomas Maurer, and by that emphasis put on his Antranen nationality, were you after diplomatic protection to be held by Antranen, or maybe you were just pointing out his probable impartiality? Which one?
Both. Both.
Thank you.
Hello, my name is Hannah. I'm from ATU, Iran. And my question was with issue 4. So there is this way for the respondent team to come up with the argumentation of the resolution being ultra vires. The question is, many teams invoked Article 2, Paragraph 7 of the UN Charter and others 27, Paragraph 3 with regard to voting and unanimously. So would you say that, I mean, during our researches, we saw that the examples of invocation of Article 27, Paragraph 3 are rare. But did you anticipate the teams going after the voting process and, I mean, hanging the unanimously wording of the case?
Yes. Yeah, because there is such limited practice on states complaining about so-called interested states voting. Yes, it was intentional.
And would you say that it rendered the resolution 99.99.7?
Here and after the resolution.
Ultra vires?
Sorry?
Ultra vires.
Would it?
I don't think so.
At first, I don't think it is factually ultra vires, but also there are so many challenges to the ICJ making pronouncements in respect of that we were hoping we wouldn't go there, honestly.
But do you think it's realistic that the UN Security Council would issue a resolution on an issue like this?
No.
Okay. Just wanted to make sure.
It's just 40 people, no.
Thank you.
It's not just 40 people, Dagmar.
Good afternoon. In 3 minutes, Your Excellencies. Also, my name is Maria. I'm from Team 784 of Uzbekistan, and I've been playing both applicant and respondent for the first 2 issues. And the hypothetical and both hypocritical question which we faced, which I like hypothetical questions, but they are slippery slope, was how far does the scope of DCA on the image of the Queen stretch? Because one of the questions I can quote from the judge is, can her pictures of her vacation with a bad headline on news be defamatory, or her, also quote from the judge, smelling bad being defamatory? So how far does it stretch?
I think absolutely is a question within the problem that we wanted you to deal with. These laws exist in countries around the world, and there are prosecutions on things that in other countries may seem silly, but are of vital importance to the country that carries out that prosecution. And so that was part of what I wanted you to be thinking about in that question of what is sovereign, is what does a state get to say about what it thinks is vital to its interest? And how far can other countries go in saying, no, that's not vital to you? So yes, we wanted you to test that.
And I personally very much thought about what's happening in the world now, and how governments justify doing things that most of us would agree are not lawful, by saying, well, this is in our vital interest. So I was very interested in the answer to that question.
Thank you, Alex.
Maurer, and I have a question for my colleague because she's ill now, but she related to questions 1 and 2, and it concerns the Stanford debate declaration of nationality and the CRS convention, and she asks whether Article 8.3a or 8.3b have been used for the applicant. So 8.3 is about 8.3a is about just something being inconform with duty of loyalty, and 8.3b is about declaration or allegation that the person is no longer, like, sorry, let me quote, that the person made allegiance to another state. Do you think, or were you considering which whether base articles necessary to argue for the applicant or for the respondent?
I think we tried to leave it open for agents to choose which arguments they wanted to advance. So we try not to lock you in too closely on what specific parts of articles you have to argue. We want you to make that choice.
Oh, thank you.
Hi, good morning. My name is Sarah. I'm from Belgium, and we were wondering what was the real relationship between Queen Asaf and Saki.
Yes! Well, now you have to say it.
Well, now it's out.
So Dagmar didn't know it until this morning, but they are very close. And in my mind, Saki Shah is not dead. Antrano helped her flee back to Italy so that she and the Queen could, resume their relationship.
Hello.
No disrespect to the crown intended.
Good afternoon. My name is Yewan from South Korea, and I have 2 questions regarding the factual details.
Can you pick one of them?
Pick one, please. Time.
For the latter one, there were some kind of very specific facts regarding the regional headquarters like Melbourne, Dunia, Kinshasa, and I was wondering, was there any intention of the drafters of the compromise to lead the students to certain cases like Ahmadou Diallo case, because the specific regions were actually, I remember some of them are from the cases, like Kinshasa Diallo case, so I was wondering, is there some certain intentions and more than those kind of things?
Yes.
Mm-hmm. Absolutely.
Yeah.
Thank you.
Good morning, my name is Michael from Boston University. It's an inverse problem. The question is regarding the drafting process. You alluded to this earlier, but in the balancing of facts and issues for both of the parties, I was curious about the back and forth between the drafters about how you find that balance so that one side isn't so clearly victorious.
That is the drafting process in and of itself. And there was a lot of back and forth, and you haven't seen a spreadsheet till you've seen a Michael Pyle spreadsheet once you're trying to do the clarifications and going through all of that. So it's the entire process. And that's why we, I think, have authors and a committee. Jeff said something fairly insightful to me this morning.
I did.
Yes, you did. Basically, he said that there's no way, even with that setup, that we're going to be able to get it perfectly balanced. But at least we rely on this teamwork approach to get close.
I have a memory of Dagmar in the 2016 East Agnostica case. I'm such a nerd that I remember quotes of them speaking on authors' tables from past times. But in 2016, you said something really profound about the worry you have as a coach to your students about not wanting to have one team represented. You said it better than I will.
I said I don't want one team to have to be the black-hatted weasel of the apocalypse.
Exactly what you said. And so that's the challenge, because otherwise it's really hard to always be the bad guy sitting in front of a bench of judges trying to defend the bad guy's attitude.
Mm-hmm. Yeah, that's right.
Thank you.
Good morning.
I'm Matin Amiri from Iran. Thank you for the case. You really tortured us. You've received a lot of pleadings and arguments. You've received hundreds of memorials. Who do you think wins the case?
Oh, that really depends. I think there are ways for both countries to win the case. I really do. I'm not making that up. So I'm not sure I have to pick a favorite child.
Oh, I don't think I can pick either. So we'll say she chooses Antrano, I'll say Ramuzia.
There we go. That works. Wait, no. Mulvania wins.
Oh, sure. Queen Cassatt wins.
Thanks. Hi, my name is Ali. I'm from Tufts State University of Law, and my question goes to claim A. When you were drafting this claim, did you think of the right action to enforce obligations erga omnes partes under the State Business Convention? Or the focus was more on what right articulate is an erga omnes partes obligation?
Both?
Both? Yeah, you have to have both. So yeah, absolutely.
Hi, I'm from China, and my question is relating to issue 4. And as you have said before, the insertion of the international is intended to establish standing under diplomatic protection, and the clarification also relates to a declaration in that respect. And that has given us really hard time in picking the legal basis under issue 4, where we consider that even considering that the convention could confer standing under diplomatic protection, and that would not give us standing directly under the UN Charter. So we were considering, what is your view on the relationship between the convention and the UN Charter? And were you actually intending us to argue a Article 25 of the UN Charter as an erga omnes partes?
Oh. No. To that second part, no, I don't think we were expecting an erga omnes partes argument for Article 25. As to Antrano's standing, one of the many challenges we faced with the fourth question presented was, how do we get Antrano sufficiently involved such that we don't need the United Nations to bring the claim itself, because then things go off the rails. And so we recognize the standing challenge posed by the position we have the Security Council resolution in, but we, I think as a committee, couldn't really find or think of a better way to make it work.
Right. I think that's right. Yeah.
So is there a possibility just to argue so-called standing under the resolution itself instead of separating the standing under different substantive obligations under the treaty?
I think a team could choose to make that argument. I don't know that I would personally consider it a strong one.
Agreed.
Thank you.
Okay, we have 10 minutes, and so we're going to start the speed round where we'll take 2 questions at a time. Okay? Yeah, go ahead.
Hi, my name is Brianna from Case Western Reserve University. My question has to do with the UNLP-UN certificate distinction. So in the course of the drafting, Dr. Malik's documentation was changed from a UNLP to a UN certificate, and I was wondering what the reasoning behind that decision was and what effect, if any, you foresaw that happening on the problem.
We thought it placed a little too much of a thumb on the scale for one side versus the other.
Yeah.
Thank you.
Hello, my name is Karim Samoa from Sierra Leone. My question is, what is the rationale behind the deposition and the Privilege and Immunities Act?
The rationale behind the privileges and immunities?
Yeah, the deposition, the declaration that was made in the Privileges and Immunities Act, the clarification.
That the applicant has your declaration.
Oh, to help solve the question of standing for the applicant to bring the fourth question before the court.
Right.
And on the UNLP, I'll just add that we have friends of the Jessup everywhere, including at the UN, and so they also came to us early, to Michael Pyle, and said, we don't think that's the process that would happen in real time.
Yeah.
Good morning. Just returning to the possibility that there is a legitimate argument that the resolution is ultra vires, how did you reconcile a declaration by the court to that effect with the court's explicit rejection of any role of judicial review at all? And if that was a thought process, did you consider the distinction between JR and a sort of incidental review of legality?
Absolutely, we did. I think that tied into a question earlier, and that's why we structured it this way, because we really were cognizant of the limitations of the court's power vis-a-vis what the Security Council does. So yeah, absolutely, that tied in there. Yeah.
When I tell you the number of changes we made to that resolution, it would blow your mind.
Yeah.
Hi, Kavya from India here. Quick question on the first issue on standing. I remember you mentioning that you were thinking about how the right to nationality is so vital now, that it is the source of every other right, and is it erga omnes partes in that effect, erga omnes? Were you also anticipating that teams would take a very zeroed-in approach on the compromissory clause of the CRS versus the Convention Against Torture and Genocide Convention, and whether that would be such an integral argument when you were first drafting it?
Yeah, absolutely. I mean, there is tension there, right? Because the ICJ can't just open up the floodgates and recognize everything as erga omnes simply because it is partes, right? Can't do that. So we were absolutely looking at that and I wanted people to abstract the notion of why we have erga omnes partes obligations in the first place, rather than focusing on, well, we only did it with genocide and we only did it with torture. I wanted a much more abstracted thinking process there.
Yeah.
Thank you.
Hi, I'm Tanvi from India. My question is regarding issue 2, regarding Article 9 of the Convention. Do you think the act of 740 was political in nature?
Do I personally think it was political in nature? Yes.
I don't.
Thank you.
Hi, I'm Divya from India. Coming back to your earlier rejection of abuse of rights by Ms. Sati Shaw when she obtained Remisian nationality, considering that this court, the ICJ did analyze the reasons behind not applying for Liechtensteinian nationality, and then going into why that in itself should be recognized, how then did you try to balance out the arguments on both sides? Because our team's approach was that reasoning behind the genuine link connection being established is integral as not.
I have to confess that I think I heard the abuse of right argument a couple of times, and the problem with it is that I didn't hear anyone properly articulate the doctrine of abuse of right, which is actually a state abusing its right. And the reason I didn't like that line of argumentation is there's no indication that the government of Remisia somehow knew Ms. Shaw had some sort of terrible motive to get her nationality. So the argument of abuse of right for me broke down due to a lack of knowledge on the part of Remisia of any secret underlying motives she might have had.
Yeah, and I think that goes to something that we really want you to remember, which is the compromis as a document is a set of stipulated facts between the parties. And so that fact, that necessary fact wasn't there. And I don't think Toronto probably would have agreed to that stipulated fact, certainly. I don't know that they could have. So I think you are limited by what your states have consented to as the facts.
Thank you.
Hello, I have two questions. Did you
Pick
want
one.
us to
Pick
Get one question.
Thank you. Two, please.
No, because we need to finish on time.
Yeah. Did you want us to use the extradition to talk of how effective consular protection cannot be guaranteed?
I missed the first part.
Did you want us to use the extradition to talk of how effective consular protection cannot be guaranteed by?
I don't know if you think of it. I don't think we thought about it. Yeah, I don't think we thought about it, to be honest.
Thank you. Thank you.
Hi, I want to clarify something in question 3. Is the principle of non-refoulement applicable in cases of consular assistance, in case of Ms. Sati Shaw, or in similar cases? And was the respondent expected to use this principle in his arguments?
I don't think that we expected or wanted you to look into non-refoulement. I think because we were focused so distinctly on consular access.
Yeah, I think that's right. And also, of course, non-refoulement deals more with someone who is being returned to a country, not where they're being criminally charged, but rather where they would be treated badly in some way or other on a protected ground under the convention. So non-refoulement really doesn't apply here.
Thank you very much.
I just want to clarify some facts about the Stay in 40. Are all of the Stay in 40 college or some of them high school students? And also, I didn't
college students and high school students.
Yeah, some of the facts mentioned, there are high school students participating in the protest. And also, did you want us to look into the fact that the trials for the Stay in 40 were done online and maybe have the effect of how they became stateless in the judicial process of the NC?
Opinions on that one?
So first, we certainly didn't want you arguing that the Stay in 40 were minors, certainly. And I hope that the commentary was clear enough on that, although we didn't address it in the clarifications. As to the online trials, I would say if there was a red herring, that's probably one.
I was militantly opposed to invoking the ICCPR on substantive grounds, because that would have taken us in a completely different direction.
Last question.
Hello, good evening. I'm from Iran. My question was exactly regarding ICCPR, whether the applicant, the applicant in the second issue to invoke the ICCPR, and in this case, it was how to base the standing on the erga omnes partners or
Absolutely not.
so only CRS and CS.
Right. Yeah.
Okay, we survived. So let me just say one final thing, which is I don't think you understand how much work goes into drafting these problems and how little credit the people who draft it, let alone draft it more than one time, get. And so this moment is probably the only moment where there's a group of people who can literally give a huge round of applause for these people. And with that, please join us at 2 p.m. for the final round of the Jessup right here in this room. Have a great day.